Thank you, Gwyneth. Appreciate the opportunity to preach. I'm Dan McIntyre. I'm a lifelong paddler, canoes, kayaks, anything that will float. In my normal life, I'm a mild-mannered corporate securities lawyer. Then I put on my cape and become the river defender. And I've been involved in all of the important litigation and efforts at legislation in the river access area for about the past 30 years. Today I've been given the modest task of teaching you 800 years of river law in 15 minutes. So hang on to your seats. If anybody would like to discuss any of this further at lunch or any breaks or afterward, I would be pleased to do so. There are three basic legal issues that are pertinent to building a paddle trail. And I like paddle trail because it doesn't threaten the landowners like Blue Trail does. They're envisioning people walking through their land at that point. I think paddle trail is the most defensive description we can use for what we're doing here. The three basic issues are you've got to get access to your put-ins and your takeouts. Rule number one, you got no right to cross private property to get to the river or to get off of the river. Maybe in the case of an emergency, but we're not there. The second legal issue is you got to get sufficient control over that long site to build what you want to build and operate like you want to operate. And the third issue that I'm going to spend most of my time on is what rights the voters have once they get on the road. So let me quickly address the first two of those issues. The first thing you need to do if you're going to think about a canoe trail is get a lawyer on board. That legal planning has got to be done from day one, or it's not going to happen. Don't be bashful about asking the lawyer to do this free, pro bono publico. That's our duty, to do that sort of stuff. Get a lawyer who knows something about real estate law. Not everyone does, but almost all country lawyers know enough real estate law to provide you with legal advice that you need on these access issues. How do you get to the river, and how do you get control over the long sites and the takeout sites to do what you want to get done there. Address the legal issues on the front end in the planning process. Identify them, address them, know how you're going to do it. Otherwise, they're going to rise up and bite you at exactly the wrong time. Guaranteed. Now on to river passage law, which I think is what most people are interested in. That's law of ancient origin. It starts with the Magna Carta, which is something that you might have heard of somewhere along your educational. It's changed a lot through the years. And if I had an hour or so, I'd love to trace that history for you, because it is very, very interesting of how we got to where we are on these river passage issues. But they all respond to economic reality, social mores, and the politics of the time. And you've always got to be aware of all of those when you're building a trail. Let me begin with the good news. River passage issues are rare. I've been doing this 30 years or so, and we've had, maybe a dozen battles. At this time, I am aware of 3 short segments of rivers in Georgia that are legally closed. almost all access problems are solvable with a little goodwill and negotiation with the people who are causing the problems. The most recent problem we've had was up on the Toccoa, there's Forest Service trail up there. So the Forest Service got very involved in negotiating with the landowner, and we were able to resolve the problem with an educational program that to put in, and lots of posters, and so forth and so on. Don't create a legal battle. You can solve the problem through negotiations in good faith. The second good news I've got for you before I get into the bad news is the federal law is that we can paddle anything that will float our boat under any sort of normal water conditions. The United States Court for the Northern District of Georgia has ruled that the Dog River is open to paddlers. The Dog River is in Douglas County, and you can only paddle it after a big rainstorm or in a very wet winter. It's a rare treat when the dog runs. But it, according to federal law, is interpreted by our court in the Northern District of Georgia, is open for paddlers, despite the fact that Douglas County tried to close it. And we've got the order that we love to cite that says exactly that. The bad news is that Georgia law is an abomination. That's the only way it can be described. A combination of what the legislature did back in 1845 and what the Georgia Supreme Court has done in the 1990s creates a fabric of law that has led to a belief among some people of a lot of things that simply are not so. This is an area where a lot of people know as a fact things that are simply not so. And the first issue that you'll hear from some people, particularly the extreme property rights people, is the proposition that if somebody owns both sides of a river, they can close it. Let me assure you that is not the law. That is not the law. The law is incredibly more complicated than that. Part of that is because people confuse the concepts of navigability and the concept of the rite of passage. Those are not the same thing. And that is particularly important to this group of people who are building river trails. Now, that's the climax of this talk, so I'll just give you that little teaser.
Dan, say that again, please. Navigability.
Navigability and the rite of passage are two related but different things. You know, where we start on all of this, as I mentioned before, is the Magna Carta. John, by the grace of God, King of England, Lord of Ireland, Duke of Normandy and Aquitaine, and Count of Anjou, to the archbishops, bishops, abbots, earls, barons, justiciaries, foresters, sheriffs, stewards, servants, and all the bailiffs and liege servants. Greetings. And of the Magna Carta, 4 sections address what we're doing directly. 33, all fish weirs shall be removed from the Thames and the Midway and all the rivers in the realm. It ain't legal to block the river so you can't get down it. All merchants may enter and leave England unharmed without fear, and may stay and travel within it by land or by water. And that got all of this tied to merchants, and that creates some complications for us as recreational paddlers. And so it's important that we emphasize this economic stuff that you were talking about here. In the future, it shall be lawful for any man to enter, leave, or return our kingdom on land or water. And finally, all forests, and that was a specialized word. A forest was actually an area that had been closed to everybody except the king and a few favored people. They've been created in our reign shall at once be disafforested. What a wonderful old English word. Riverbanks that have been enclosed in our reign shall be treated similarly. Now, we're not that good a shape over here, but they are. In England, you can cross anybody's land over there in the UK if you don't intend and don't do any damage while you're at it. In deference to time, I will make a quick 600-year jump to where the Georgia Supreme Court is right now. Itchway-Notchaway Creek in Baker County has a long history of being used by substantial sized boats. It's a John boat river. The lower section of 4 miles has been declared navigable by the Corps of Engineers. The locals have been boating on that river forever. On the banks of the Itchway-Notchaway is the longtime venue of the Woodruff, as in Coca-Cola, quail plantation. And there is a long history of bad blood between the locals and the Woodruff forces down there. And I can tell you a couple of hours of interesting stories I've heard about tying fire to cats' tails and sending them across the land out there. Unfortunately, the current occupant of that land, our supposed friend, the Joseph Jones Foundation, decided to carry that feud up into the 1990s. And they declared that Itchway-Notchaway, as it flows through their land, was closed. A great American by the name of Carroll Gibbons took that on, and he tried to float down with a raft with 2 bales of cotton and a billy goat, saying that would prove that boats floated with freight. And it did, but he wound up in court, not before a jury, where he would have won, but before a judge. And the prevailing evidence in that case was an expert witness recommended by the Georgia Department of Natural Resources to the Woodruff Jones group, who testified that the test for navigability of a river is whether it will transport barges 245 feet long, 35 feet wide, and drawing 7.5 feet of water. And that was approved by the Supreme Court.
7.5 feet of water? What?
Yeah.
Deep?
Yeah, draft.
Draft, okay.
Principal lesson we take from that is you've got to get your politics right before you go to the Supreme Court. But there's silver linings. First, the Supreme Court expressly said that it was not ruling on the federal law because it hadn't been raised by the lawyer in the trial court in Baker County. Secondly, and most pertinently here, the Supreme Court has told us in that case that there is a public easement created by a history of use of water. And anybody can traverse a public easement. But their ruling in Itchway-Notchaway is no public body had ever claimed that easement. So what's got to happen is if we declare it a canoe trail and we get a public body, county commission, city, any public agency, to declare that canoe trail and do it correctly with the resolution that Charlotte and I worked on a few years ago, and we'd be happy to share with you at any time.
It's on the website. It's on the clearinghouse website.
I am convinced that that is going to prevail, and we're prepared to take that up to the Georgia Supreme Court with you on the Georgia Canoeing Association.
Awesome.
Woo!